So the justice area of the European Union is more or less quite a new development. You know, what is today called the European Union started in the 50s with the Treaty of Rome, 57, in the form of a European Economic Community. Through its development, it really changed in its nature. It was intended as a kind of zone of free movement of goods, services, people, but it became something more. At the end, what it is today, it's a political union, and it's, in my legal evaluation, a federal state. We had a debate recently about this at another lecture organized by the Institute of the European Studies, if the European Union is a federal entity or it is not a federal entity. It has all the elements or the supplements of a federal entity. You have like something like a constitution. It is called the treaties. It's not called the constitution for political reasons, but it fulfills the same function. You have something like a Bill of Rights, to compare it to the US system. We have something called the EU Charter of Fundamental Rights. It's the same as the US Bill of Rights, and it's obligatory. It has an obligatory value. Then we have like a federal parliament. We have a federal government. We have the supremacy clause, what is called in EU law the primacy clause, meaning that federal law breaks national law. So you have all these components of a federation, although there is a joke in the European Union, never use the F word, meaning federation. Especially some member states are very reluctant to call the European Union a federation, like the UK, for example. And if you followed a little bit the recent debate about what is called the Brexit, meaning that the UK would leave the European Union, there was now a kind of new agreement with the UK that has to be confirmed in a referendum in the UK very soon. I think it's in June. And in this document, the UK, what I was told, was very careful also to draft in that the UK should not be somehow forced to become a member of an ever-close union, which it is already a member. So it's like a little bit a catch-22 situation. So we have all the components of a federation. It's working as a federation, but out of this political reluctance, sometimes the EU is like not perceived, at least in some member states, as a federation. That you a little bit understand the debates we have in the EU. It's interesting to compare these debates historically with the US, because I think the structure of the US also changed over time, especially after the Civil War. With the introduction of the 14th Amendment, the structure of the US nation changed a lot. Perhaps before the Civil War it was much more confederate, as it was after the Civil War. And historically also the European Union is changing its nature. So it started as an economic union and now became more or less a full-fledged political union, dealing also with justice and criminal law, as we will see further. It's interesting that we don't speak about EU criminal law not till 92. So what started as the European Economic Community in 57 didn't deal with criminal law till 92. It's a really long lifespan. What happened in 92? In 92 there was a big, let's say, constitutional change in the EU. The notion of the European Union was introduced, but this European Union was supposed to be structured out of three pillars. The European Economic Community, which was a full-fledged legal person with all the institutions, and then they created two additional pillars. One was the common foreign and security policy, and then you had a third pillar, which was justice and home affairs. But in this beginning period, 92, actually till 99, there was not a lot of movement, or actually no movement at all. We start to speak about EU criminal law only from 99 on, because in 99 there was another structural change of the European Union. It was with the Amsterdam Treaty, so there was a change to the main treaties. With the Amsterdam Treaty they left this three structure pillar, but they modified and made the criminal law structure, the justice and home affairs structure, which was considered the third pillar, much more effective. What did they do at that time in 99? They introduced a new kind of legal instrument. It's interesting because in the European Union, out of these political reasons, we don't have something legally that is called laws. You don't have a European law. You have the laws in the form of two instruments, either regulations or directives. They tried at the beginning of 2000, there was a debate to change also the terminology in the treaties to introduce the term law, but again, out of political reasons, it was not introduced. So again, the main instruments for adopting legislation in the European Union are two: regulation and a directive. What is the difference between a regulation and a directive? A regulation is a directly applicable law. It's with all the elements of law and it has to be directly as it is applied in the member states. A directive, on the other hand, it's a little bit more complicated. It's a kind of framework law that has to be transposed in the national states. So usually it cannot apply directly. It has to be first transposed in the member states, and there is always a transposition period. What happens if a member state does not transpose a directive? At the end of the transposition period, there are penalties, quite huge monetary penalties. The member states is being brought by the Commission, who is like the EU government, to the Court of Justice. We also have like something that, like the US Supreme Court, that is called the Court of Justice of the European Union. And this court pronounces these very high penalties. It also pronounces that there was a violation, a non-transposition of EU law, and this court also developed through its case law the notion that if a directive is not transposed in the due time, then it can be applied directly if it has enough elements and components to be applied directly, which is much more problematic in the criminal law sphere because you cannot apply a criminal law without its publication in the official journal and so on. So it wouldn't be possible to transpose, let's say, a criminal material law directive introducing a new offense with penalties in this way directly to the member states. But I go back to this Amsterdam Treaty and to this big constitutional change in 1999. This treaty introduced in the third pillar of justice and home affairs different instruments. So they were not directives and regulations, but the main instrument was called framework decisions. What was the difference between a framework decision and a directive? They are very similar in nature. A framework decision had to be transposed in the member state, but the difference was if it was not transposed in due time, there was no sanction. So in the criminal law sphere, there was from 1999 till for 10 years till the Treaty of Lisbon in 2009, there were no sanctions. Usually member states transposed them, let's say more or less, but they were not obliged to transpose them in the way that they could be forced, that they would be penalties if they wouldn't transpose them. And the Commission couldn't sue them in front of the Court of Justice of the European Union. You might think that this system is a kind of semi-fledged system without proper sanctions, but it functioned quite well. And the development of EU criminal law really started after the EU Amsterdam Treaty. The EU Amsterdam Treaty, after the adoption of the EU Amsterdam Treaty, let's say there was also politically the time arrived that they wanted to have more integration as regards criminal law. In addition, there were also the terrorist events of 11 September, and this triggered in the beginning of 2000 a big program of harmonization at federal EU level of criminal law. They also introduced an interesting concept, the concept of mutual recognition in the EU. This concept existed already before in the sphere of economic liberties in the European Union, meaning that once you introduced a good legally in a market of a member state, it could circulate throughout at that time, the European Economic Community. So it's an old notion from the 60s, mutual recognition. It applied first to free movement of goods, free movement of services, the recognition of diplomas, interestingly, the recognition of driving licenses. But in 1999, they decided to apply it also to criminal law. Of course, applying it to criminal law it's different, because before it served the individual, an individual citizen. Of course, it's my interest that if I produce a good and it's legally recognized in one of the member states, that it would be also recognized throughout the territory of the European Union. The same is true for my diploma. If my diploma is recognized in one member state, it should be also recognized in the other member states. But when we come to the realm of criminal law, it's more complicated, because there more or less was the interest of the law enforcement and judicial authorities to introduce the notion of mutual recognition. So they introduced it in 1999. It didn't have a treaty basis at that time. It was not written into the basic documents, but it was a kind of political decision at a very high level in 1999 by all heads of states at a certain meeting they had. They introduced this notion and they started to adopt important instruments in this third pillar, justice and home affairs, based on this notion of mutual recognition. The first instrument that was adopted in that regard was the framework decision on the European arrest warrant, meaning that there should be an automatic extradition of fugitives or people who were already convicted between the member states. It was not totally automatic. There were still some possible non-recognition grounds, like nebis in idem, the prohibition to be judged twice for the same crime, and so on. There were certain elements where you could refuse the extradition of a person, but they were very limited. In the US, the system of interstate extradition is much more based on soft law and agreements, let's say model agreements between the federal states that function very well, and that function so well that all the federal states in the US joined in. In the EU, the approach is it's a different one. It's much more based on, let's say, hard law, not on soft law, but on hard, very precise legislation. Is this good or bad? It has, let's say, advantages, and it has some negative sides. The negative sides, the advantage is that you have a clear law that applies to everybody. The negative side is that sometimes there is the perception if something is not written directly into law, it doesn't exist. And I bring you back to this notion of the European arrest warrant, because this European arrest warrant from a law enforcement perspective really functioned very well, meaning that there were massive extradictions of persons between the member states of the European Union. So they even extradited people that they didn't extradite before under the old system of extradition. Suddenly they started to extradite people in a speedy way. However, in certain specific cases, it was discovered something that was not taught well before, that there are huge differences between the member states as regards the level of fundamental rights. Let's say, of procedural rights, of fundamental rights. There was also a certain necessity for harmonization of criminal material law, meaning introducing common EU criminal offences. Why? Because, for example, the European arrest warrant, this common instrument for the extradition between the member states, also replaced the notion of dual criminality. For a certain list of 32 offenses, it was thought that there is no necessity anymore to check dual criminality. You know, in the normal extradition procedure, also in the international extradition procedure, you always need the duality of crime. Something that is an offense in my state has also to be considered as an offense in your state, that the person is being extradited. So this notion was abolished for 32 offenses. Not all of these offenses are harmonized at federal level, but some of them are harmonized. So this triggered another notion that additional framework decisions were introduced on certain crimes, like for example, terrorism and so on. So that is like considered as a federal crime in the EU. The same for combating sexual abuse against children, trafficking against persons. So there is a notion that there are certain federal crimes for which the EU is responsible to legislate on them. But this was all triggered, let's say, with the European arrest warrant as the first instrument. However, the European arrest warrant, it triggered another debate. In specific cases, it became very clear, as said before, that the level of protection of fundamental rights is very different between the member states. And you might think that there might be a difference between, I don't know, the new democracies from East, and that Western member states would be much more developed as regards the protection or the procedural rights in criminal procedure. No, it was not like this. I have to say, I'm myself from Slovenia, so perhaps I'm not so objective, but as a new member state. But what was found out through reports that through a certain study that the Commission ordered itself, the European Commission, that a lot of member states, for example, didn't have the Miranda warning system. So you had a right to remain silent, but never in the procedure you were told that you have the right to remain silent. So it existed theoretically, but there was never an effective information that this right exists. Then you had other member states where you didn't have a right to a lawyer during police interrogation. For example, in France, you got the right to a lawyer during the initial police interrogation. I think it was only 2010 or 11 when the system was changed. And the more funny thing is that this change of the system in France, Belgium, was triggered by a Turkish case in front of the European Court of Human Rights. There shouldn't be a mixture between the European Union and the European Court of Human Rights. The European Court of Human Rights is a specific additional European body. It's an international court responsible for fundamental rights, and in addition to all of the members of the European Union, also about 20 other European states are members of this court, for example Russia, Armenia, Turkey, and so on, and it deals specifically with fundamental rights, human rights violation based on the European Convention on Human Rights. But this court is very influential in general in whole Europe and also in the European Union as regards the understanding of certain fundamental rights. So this court in 2008 established a violation in Turkey as regards the right to a lawyer, and this 2008 judgment was the Saldus judgment against Turkey, triggered legislative changes in France and Belgium. So there sometimes let's say that this legal development historically is a little bit funny, that the judgment against Turkey triggers legislative changes in France and Belgium. There was another big change. I told you we have something that is called the EU Charter of Fundamental Rights that is comparable with the US Bill of Rights. And this charter before was of a declaratory nature. It was adopted already in 2000, but was of a declaratory nature. But with the Lisbon Treaty, it became part of the treaties, and it's now a full-fledged legal instrument. And this charter, here we have a difference with the US system, but a very interesting difference from a historical perspective. You also know the Bill of Rights. The US Bill of Rights, when it was adopted, it was meant to cover the federal level. You only have afterwards an introduction of the Bill of Rights to the federal states through the US Supreme Court. So the US Supreme Court integrated the Bill of Rights to the individual states, federal states in the US. We have the same problem or the same issue in the European Union. The Charter should apply only to the application of EU law. So the level of fundamental rights protection of the Charter should apply only when EU law is being transposed and is being applied. So it does not apply to purely national situations in the member states. If there is a pure national situation, the level of the Charter should not apply. You have a specific provision, I think it's Article 52 of the Charter, that, or 51, that provides about its legal implications. However, this is not so easy, and I think we will experience in the European Union a very similar development you had in the US, that the Charter has to be integrated also in purely national situations in the member states. Why? Because you cannot have two levels of fundamental rights protection in the sense that you could get a reverse discrimination effect in the member states. Imagine a criminal court procedure where you have, let's say, a federal crime and an entity that is called the European Public Prosecutor. I will speak about it a little bit later. And you have a purely national situation, let's say the theft of funds. You have the theft or the embezzlement of funds of Slovenia as a member state, and you have the embezzlement of funds of the European Union, because the European Union has its own funds. You would have the same national judge in Slovenia responsible for both cases, but in one case you would apply one level of fundamental rights protection, and in the other case you would apply another level of fundamental rights protection. Because we have a big difference in comparison with the US. This is, we do not have a federal judicial system. We have one Supreme Court, like in the US, we have the Court of Justice of the European Union that is very similar to the US Supreme Court, but all the rest lies on the national judiciary. So we don't have federal courts in the European Union. And therefore you have the same problem, because the same national judge would be confronted with two levels of fundamental rights protection. In the US, this does not happen. Why does not happen? Because you can have a federal judge or the federal judiciary, and you have national judiciary. But in the EU, we abolished. We do not have federal judiciary, we only have national judiciary. And I think there will be, in my opinion, in the future, a tendency to integrate the Charter more and more also to purely national situations. So our Federal Bill of Rights says that our understanding of fundamental rights can never go below the understanding of the European Convention of Human Rights. However, we have a lot of member states who have in their national legislation a higher level of fundamental rights protection. I give you an example. The right to remain silent is considered a relative right in the United Kingdom. It's not an absolute right in the United Kingdom. It's a relative right, meaning that the judge can interfere negative consequences from when you use your right to remain silent. This is not the case in other member states, like in Germany or Slovenia. This is an absolute right by the Constitution, and the judge cannot infer any negative consequences if you use your right to remain silent. So you already see we have a common federal level, but the national constitutional level can be much higher. It's exactly the same as in the US. You have like the federal understanding of the Bill of Rights through judgments of the US Supreme Court, let's say the right to a lawyer, the Miranda warning systems, exceptions to the Miranda warning systems, and so on. But national constitutions of the federal states or the constitutions of the federal states can go higher. I was only told, and I checked this, that in California, I think in '82, there was a constitutional amendment to the Californian Constitution saying that higher levels of fundamental rights protection of the Californian Constitution shouldn't be a detriment to use evidence that fulfills the federal standard. So in California, apparently in '82, there was this constitutional addition that you can use also evidence that would be considered as inadmissible with the Californian Constitution, but it fulfills the federal level of the Bill of Rights. So we have the same issue in the European Union. We have the federal level, and then we have the national constitutions. But our situation is legally a little bit more problematic. I told you before that as in the US, we have a supremacy of EU law, meaning the federal law breaks national law, or the law of the individual member states. However, this notion in the European Union, it's not written in the treaties, it's not written in the Constitution as you have it in the US. It's a development of case law, very early case law of the Court of Justice of the European Union. There was a case from the 60s from Italy, Costa versus Enel, and in this case, Costa versus Enel, the Court of Justice of the European Union introduced the notion of primacy of EU law. But it's not a concept that was ever directly written in the treaties. Why not? Because this concept was challenged in the 70s and 80s by some national constitutional courts, especially the German Constitutional Court, because Germany considered that they have a much higher level of fundamental rights protection, and the German Constitutional Court adopted two very known decisions. They are called so lange decisions, meaning it's the German word so lange, meaning as long as. Why they are called as long as? Because in the first of the decisions, the German Constitutional Court said, as long as at that time the European Economic Community does not fulfill a basic fundamental rights protection, we will keep the prerogatives to be the last decision maker about the protection of fundamental rights as regards at least German citizens. Then some years later, they reversed this decision in the way they said it now in a different way. They said, as long as the EU or the European Economic Community at that time would protect fundamental rights, we give up our prerogatives. So this means that the notion of supremacy of EU law was never totally adopted or totally agreed upon by national constitutional courts. And therefore, you have in the Lisbon Treaty, the latest version of the treaties, you don't find the supremacy clause written in the treaties itself. You only have a declaration, I think it's declaration number 17 by all the member states, that they will continue to respect the case law of the Court of Justice of the European Union as regards the application of supremacy or primacy of EU law. However, in the realm of criminal law, we have other warnings of the, let's say, for example, of the German Federal Constitutional Court. When the Lisbon Treaty was adopted, this really big, the last big change that really changed, in my opinion, the EU into a federal structure. The German Constitutional Court, the treaty was challenged in Germany because each member state had to ratify it, and the German Constitutional Court, for example, said that that they will respect the prerogatives of the EU. However, they would still keep the possibility to intervene, especially in the realm of criminal law, if the basic notion of the identity of the German state as regards fundamental rights protection would be challenged. And in the realm of criminal law, we are very quickly in this notion of some fundamental rights protection. So when we adopt measures of criminal law in the European Union, we have to be very careful at federal level that we really adopt the measures at a very high level, that we would never trigger this very dangerous and political problem about the notion of supremacy of EU law. So we really don't want to bring a national constitutional court into a position to have a direct confrontation with the Court of Justice of the European Union. There is still a big unsolved problem in the European Union between the member states, a real legal problem that is about admissibility of evidence. We do not have common rules on admissibility of evidence. And in these instruments, we couldn't agree on any common rule as regards admissibility of evidence. What is interesting is that there should be some common rules based already on the European Convention on Human Rights. Because the European Convention on Human Rights also prohibits the use of torture, inhuman or degrading treatment. And wherever such a treatment was used, a consequence is that evidence is inadmissible. If it was torture, then the European Court of Human Rights proclaimed that such evidence cannot be even in the file. If it is in the file, it already contaminates the file. This is also a consequence of the UN Convention against torture, because also the UN Convention against torture, I think in Article 15, has more or less the same prohibition of use of such evidence. It's more complicated for inhuman and degrading treatment, these other categories of, let's say, misbehavior of law enforcement, where you don't have torture, this massive physical, psychological and physical misuse of a person, but you have a slap, for example. A slap can be considered inhuman and degrading treatment, but it doesn't amount to torture. Can such evidence coming out of a slap be admissible or not? The European Court of Human Rights proclaimed it cannot be admissible. It can still be in the text, in the file, but it cannot be main evidence. If it is main evidence, then the whole procedure is unfair. So at least this notion as regards, this is Article 3 of the European Convention on Human Rights, is very clear, and this should be the basic, at least also in the member states of the European Union, because I told you our Bill of Fundamental Rights says that the convention should be the minimum. However, in this instrument on presumption of innocence, we couldn't agree with the member states to introduce such a measure. We have a recital mentioning this judgment as regards torture and inhuman and degrading treatment, but a recital is a non-operative part, so it's still up to the member states. But just to give you a real example that happened in my country, how problematic this notion of the different admissibility of evidence can be. There was a high-profile political case in Slovenia as regards former prime minister. That he took allegedly some funds in connection with some arms that Slovenia bought. So the company that sold these arms in Finland, apparently it was alleged, gave some bribery, not directly to him, but to his party and to some other people, but he was involved. The problem was that in Finland is a very specific country, because I think it's the only country in the European Union, and here we come to another unsolved problem of the European Union, where the police can authorize itself to make a house search. Not in urgent situations, usually in most member states, also in the US, you need a court warrant. No? if there are not some urgent or exigent circumstances, you usually need a court warrant. Not in Finland. In Finland, a policeman goes to his fellow policeman, who is a little bit higher, and asks him for an authorization to do a house search. And so there was evidence stemming out of these house searches in Finland, and there was a big legal question if this evidence and everything that comes out of this evidence and as fruit of the poisonous tree can be used in Slovenia. Because in Slovenia we have a constitutional provision that for house searches there always has to be an authorization of a judge, except in urgent exigent circumstances, and we have also the absolute exclusionary rule with an absolute rule of the fruit of the poisonous tree. Now our Supreme Court in Slovenia tries to diminish it, following a little bit the US examples, but at least by law the exclusionary rule is considered as an absolute one. So there was a real legal problem if such evidence can be admissible. I just give you this striking example to see that there is still a real existing problem about admissibility of evidence circulating in the European Union. And this brings me to the last point I want to tell you about. This is a new project or a new instrument, a new institution that the European Union wants to create. It's like a kind of federal prosecutor. So we don't have federal courts, but they are trying, or it's quite already advanced in the legislative procedure, to introduce a kind of federal prosecutor responsible, at least at the beginning, only for the offences against the budget of the European Union, meaning financial offences, because the EU gives, for example, in the field of agriculture, very big subsidies. And sometimes there is embezzlement as regards these funds of the European Union. And to provide a more effective protection of these funds, this special body should be created, and this body would then through its substitutes in each member state, would conduct criminal proceedings in the member states in front of a national judge as regards the embezzlement of EU funds. However, when the Commission made the proposal, they wanted to create an area of free circulation of evidence, meaning once evidence was legally collected in one member state, it should circulate freely through the European Union. However, this notion was not accepted by the member states, and now it was much more watered down. It has to be, I think, in line with national constitutions and so on.